Okay, we're going to go ahead and start back up. It's time for our first lightning talk of the day. Providing our first presentation will be Mr. Jerald Sanders, In Situ Resource Utilization Systems Capability Lead at NASA's Johnson Space Center. Jerald Sanders has worked at NASA Johnson Space Center full-time for 35 years in the Propulsion and Power Division of the Engineering Directorate and has extensive experience in propulsion, fluid systems, and in situ resource utilization. During this time, he has led multiple strategic plans, architecture studies, development projects, and analog field tests for ISRU advancement. Over to you, Mr. Sanders.
Okay, can you hear me, and do you see my charts that I am presenting?
Yes, we can see you, or I mean, we can hear you and we can see your slides.
Okay, well, that's more important that you actually see the slides than me. So I want to thank everybody for letting me talk today. As you probably heard, I'm a technical expert on space resources and mining, and I'm not a lawyer. So therefore, the charts you're going to see are very technical in nature. I will briefly speak to the important messages on each of these charts, but hopefully you can look them over for final details later on if you so desire. And so let me see if I can fast forward. So this chart that you see here are visions and images that I first started to see when I got into space resources approximately in the 1995 timeframe. They all showed big, vast plans. Interestingly enough, at the time that I started working this, there was very actually limited technical work that had been done, and most of it had been done in small lab settings. So great visions, but not a lot behind it. A few years ago, when I started working in space resources, typically the work was very focused on just basically what was in front of you and for a particular mission. And a few years ago, we were directed to basically show that, what is our longer term strategy? So going from those visions that we saw in the past to where we are today, we basically looked at what would be our future 20, 30, 40 years from now. And so we started to use terms like industrial scale and sustainable commodities. And the reason for that was not just think of what's in front of you, but where do you really want to go from a scalability and an operations perspective, as well as the use of the term commodities, where we, instead of consumables, on the idea that eventually at some point we're going to want to sell these and commercialize these. And so at the top left corner, the big tickets that have always been associated with space resources is the production of water, oxygen, metals, propellants in particular. And on the bottom right-hand side, how do we support sustainable, reusable space transportation systems, cislunar transportation and lunar up and down, and eventually maybe even hoppers and long-term transportation systems on the lunar surface. Eventually, we'll support the construction and manufacturing in space, as well as the longer-term human settlement and sustained operations on the lunar surface as well in the other boxes. So before going any farther, just a brief, making sure we're all on the same page. What is space resources in the utilization? We kind of give a description at the top where we consider space resources in utilization from product or prospect to product. You need to know where the resources are and how they are found and what quantities, all the way to giving somebody a product that they can use. We define ISRU as any hardware or operations that harness and utilize in situ resources to create these commodities, for whether it's robotic or human exploration or space commercialization. And I put in situ in italics because it's not just the natural resources, it's the trash, the waste, the discarded hardware, and even the spent material from previous processes as are in situ resources. And we look at it in three major buckets, three major areas. The first is the destination reconnaissance and resource assessment. Just like on Earth, before you open up a mine, you basically need to find where are the resources, how are they distributed, and eventually, are there enough of those resources to actually economically mine them? And at that point, it's called a reserve, not a resource. Once you've done that, you then go into the how do I acquire those resources? How do I isolate them, prepare them for downstream processing? And then there's the processing part. And we've broken the processing part into two major buckets. One is the mission consumables, the propellants, the life support commodities, the water, science gases, things like that. And then the feedstocks that can be used in manufacturing and construction. And so it's basically a cycle that involves lots of different players, lots of different disciplines and elements. And by definition, you do not use in-space resources unless there is a customer that wants that. Now, within NASA, a very important document that came out in 2022 and updated in 2023 is the Moon to Mars objectives. And that basically document has all the objectives and recurring objectives associated with science, infrastructure, transportation, and operations aspects. And that define what is NASA going to, why is it going into space, and what are the key objectives. Within all those objectives, if you look at them, you can bucket the ISRU related ones into three major categories. The resource assessment, there are several objectives associated with that, understanding resources in space, and particular language of understanding the potential reserves means that it's more than just science interest. Then there's the infrastructure, the space mining, the usage aspects. But in a third bucket, which is very important that we are taking very seriously, is there are several objectives associated with the responsible use of space, and in particular space mining. So the minimizing the disturbance of the local environment, the reuse of materials, and making sure that we don't disrupt any science. All of those are in that document that we follow. Another key aspect in that document is this Venn diagram on the left, and it's why do we go into space? And it's broken down into three major areas. You know, the science potential, the inspiration potential, and the national posture potential. All these are major elements, and within each one of those, there are sub-elements that pop up. The intersection of all three of these in the Venn diagram are critical and are of the highest interest. So I've tried to use this chart to show where do space resources fit into this, and in particular, the center of that Venn diagram. And we see that when we do things with space resources, it also has tremendous terrestrial and environmental benefits on Earth. We start working on things that can support renewable energy, CO2 reduction, water cleanup, and environmentally friendly mining and construction. There's a lot of spin-offs into the space applications and commercialization, the propellants, the metals, the construction. Interestingly enough, if you weren't aware, the United States and NASA basically are leading a lot of the efforts with respect to space resources and how we use them and such. And as this community is well aware, that by performing these tasks, we start establishing the norms and policy for space mining. And I believe a previous speaker mentioned the purchase of Regolith, for example, as establishing a norm. What we try to do in space will be, with respect to space mining, will hopefully continue to go down that path. This next chart, briefly want to point out the fact that we are starting at the moon, South Pole, and there are certain resources there, the Highland regolith and potentially the polar water. So the chart is meant to show that we start with what is readily available and what is easiest to get to begin with that requires the least amount of infrastructure. And that will give us a certain number of commodities or products that we think we can use right away. Those are shown in the gold, the oxygen, the water, the bulk regolith. Those are things that we think we can get to relatively quickly. Then we start thinking about, over time, adding both the number of commodities that we make as well as where else do we go. So the moon is very poor in carbon, it's very poor in aluminum and titanium, for example. So we might want to go to other regions on the moon, more in what's called the mare equatorial regions, when we want to start dealing with those kind of resources of interest, as well as thinking about going to more refined metals, silicon and ceramics, and eventually construction feedstocks and beyond. This is another one of my eye charts that I talk to with a lot of people. But the bottom line is that a lot goes into selecting where you're going to do a mining operation, starting with understanding the resources, obviously, but the fact that more is needed than that. It's just like on Earth, whether something exists, a resource exists at a location or not, doesn't mean that it's actually mineable. You have to have access to that resource. You need to be able to have power and infrastructure to support the operations. If humans are involved, you need to have habitats and such. The terrain has to be accessible. You have to have communications and navigation systems set up, as well as eventually you'll want to have a market nearby. The closer your market, the more economical it is. So all of these things factor into where you want to set up your location. And to begin with, if we're really interested in water and we're just have very limited infrastructure, we'll probably want to start thinking about what I'll call Goldilocks locations, which might be very small, permanently shadowed craters that have lots of sunlight nearby, that has a potential base or customer nearby, and all of these things come together. So this chart basically shows what are NASA's current plans with respect to space resources. And we have two pathways. One is the water in the permanently shadowed regions at the poles. This is also may have volatiles associated with it. This requires very special mining techniques, as well as, since the permanently shadowed regions are extremely cold, on the order of 40 Kelvin above absolute zero, you have to design your hardware very specifically for that. And we don't know a lot about the resources yet. So I'll show a chart that shows all the missions going on associated with it. Now, on the other hand, with Apollo missions, samples, with all the orbital assets, we know quite a lot about the lunar regolith. We still need to learn more, but we know a lot. So we're thinking about, what can we get out of the lunar regolith? Lunar regolith has over 40% by mass of oxygen, as well as these metals that I mentioned. So we're looking at performing different demonstrations, one or two, that would then get us to what we call a pilot plant. And a pilot plant is the first end-to-end demonstration of excavation all the way to creating a product in a tank, whether it's water, whether it's oxygen, whether it's fuel, whatever the case may be, at a scale that reduces the risk of doing longer-term operations and actually maybe commercializing it downstream. So notionally, we think this pilot plant should operate for about a year and about a 1/10th scale of what a future customer might want. It's supposed to demonstrate the performance, the wear, the maintenance aspects, demonstrate key infrastructure needs associated with mining. But very importantly, doing this pilot plant will also help us understand the processes and the operations that would then go into what the subsequent processes need to do to be more responsible, minimizing dust lossing, minimizing the amount of venting that occurs, and things like that. So as I mentioned on the other chart, there's a lot of interest in space resources by the US, our allies, and even adversaries for that matter. And there are a significant number of missions that are aimed at understanding these space resources. some recent ones in the past, Selene from JAXA, Chandrayaan-1 from the Indian Space Agency, and then NASA's Lunar Reconnaissance Orbiter has been up since, I believe, something like 2008, providing tremendous amounts of information. Recently, we put an instrument on the Korean Lunar Pathfinder Orbiter. We tried to launch several CubeSats to the moon recently. All of them failed. And then we have a number of upcoming missions that will start to get a little bit closer to understanding the resources on the lunar surface. Lunar Trailblazer is another orbiter, but then we start putting hardware on the lunar surface. NASA has what is called Prime 1 and Viper, which are drilling. The first one is a stationary drill. The second one is a mobile drill with instruments, as well as the Europeans are flying a drilling instrument on a US CLIPS mission, and JAXA is planning on flying what they call LUPEX, which will be very similar to the Viper mission, and may actually have more instruments. At the same time, we see that the Russians and the Chinese are aiming at creating their own lunar base, and both China and Russia have advertised different missions to the moon specifically aimed at looking at polar resources. This is another busy eye chart, but it's meant to convey the growing and expanding aspects of the interest in space resources in the US and around the world. On the top left, we have numerous space agencies that have reached out to us to talk about how do we coordinate and work together on the finding and processing of lunar resources, what are the products and such. We've initiated public-private partnerships with several companies. 3 in particular are shown here through different solicitation mechanisms. We're seeing a lot of private investment growing in ISRU outside of just government money. And we encourage our NASA centers to partner with these different companies to create new work. We're also reaching out quite extensively now to the terrestrial mining and processing markets as well as other markets. Terrestrial mining is trying to move to net carbon emissions by 2050 and the UN types of environmental aspects. So they're pushing electrification, clean energy, lots of data and such, automation. And so we're working with several companies as well as consortiums on how to leverage what they call the mine of the future with respect to space mining. Within the space community, there's lots of consortiums growing aimed at space resources, as well as establishing standards and interfaces for space hardware. And then of tremendous interest is the DARPA Luna 10 study that was initiated last October that will look into the idea of can we create a sustainable lunar ecosystem within 10 years. And whatever comes out of that study will strongly influence NASA's plans going forward. I'm not going to talk this chart either, but it's meant to highlight the fact that we take the development and use of space resources and being responsible very seriously. We released a paper at the AIAA Ascend conference last October, starting to highlight what those considerations should be and how we would start moving forward on them in terms of the operations. The fact that there is concern that space mining will impact science. And in actual fact, it's the opposite. The fact that before we do any large scale mining operations, we have to do significant resource assessment and science to understand those resources. There are the aspects of zones of permission or non-interference that we see on a mine site on Earth, that if you have unscheduled access and just show up willy-nilly, there are safety and hardware and environmental impacts that could occur. The overarching goal is to establish, lunar processing, mining, and a circular economy on the moon in the end. And I'll bring my lightning talk, I'm sorry if I've gone a little bit too long, to a conclusion, but bringing, again, the longer term perspective of space resources. We look at them as being very important to reduce mission mass, cost, and risk over time. That allows us to do fewer launches. It allows us to not rely on Earth logistics for sustainability, as well as, there's always going to be a delay between a failure in getting the spare hardware from Earth. We can reduce that. It does increase mission capabilities as well as support aspects on Earth, and can help us on Earth. And the last point is that planetary preservation is very important for us for space resources. And with that, I will bring my presentation to an end, and thank you all for listening.
Thank you very much for those very interesting comments, Mr. Sanders. I think it sets the stage quite nicely for our continued discussions on this topic. Please look for a conference coin that we'll send out to you in the mail.
I greatly appreciate it.
And with that, we'll transition to our first panel of the day for a discussion on space mining governance, private terraforming, resource extraction, and military protection of commerce. To moderate this panel, we are delighted to have Major Miles McCoy. Major McCoy is the advisor assigned to U.S. Space Forces, S4S, and assistant legal advisor to the Combined Joint Force Space Component Commander, Vandenberg Space Force Base, California. S4S, the U.S. Space Force Component Field Command and Service Component to USSPACECOM, plans, integrates, conducts, and assesses global space operations to protect, defend, and deliver combat-relevant space effects in, from, and to space for combatant commanders, coalition partners, the Joint Force, and the nation. Thank you very much, Miles McCoy. Over to you.
So good morning, and thank you. I'm honored to be here to moderate this particular panel. I'm very excited to hear what this team of experts actually has to say on this particular issue. So I'll go ahead and do a very brief introduction to the individuals off to my left. First, we have Dr. Wian Erlank, Professor of Law from Northwest University. And then we have Colonel Charles Galbreath, retired with the Mitchell Institute. And then Dr. Vanderdonk, University of Nebraska. We've seen him already yesterday. And then we have Mr. Eric Sunby, the Executive Director of the Space Force Association and CEO and co-founder of TerraSpace. And then finally, at the end of the row is Miss Emily Pierce with the State Department. And so I'd like to go ahead and just kick this off with just a very brief overview of the framework that you'd presented yesterday afternoon in your keynote, Dr. Vanderdonk, on the context of mining in space and the competing regimes, and then also specifically maybe applying to the technologies we've heard of this morning from both our keynote speaker and then we just heard from Mr. Sanders.
Sorry, I'll start with what the issue of governance is. We spoke about that briefly yesterday, and it's again, it's a lawyer's. It's a beautiful phrase for lawyers because you can turn it every which way. If you talk about governments of lunar mining, the baseline is obviously the current absence of any possibility for a state to act as if parts of the moon are subject to territorial sovereignty, which is the usual way in which states exercise governance powers over these kind of things. So we have to find a way to overstep that, and the basic idea is, of course, to create an international regime, whatever the substance thereof. It's difficult at this stage to predict how that should be developed, given also, I guess, the current geopolitical environment. At the same time, I think this morning's keynote speaker also made clear that in a sense we're all in the same boat and that we should be all interested in trying to solve these issues without any conflict if possible, which requires at least a kind of mutual understanding at the level of guidelines and recommendations on how to treat the risks to the local environment, the risks to to get into conflicts about specific places. Dr. Sanders pointed out that currently the gold mine on the moon is the lunar South Polar region. There may be a few others. So it's important to develop guidelines on how you go about there. I saw a reference also to zones of non-interference. That, of course, goes back to the Artemis Accords, referring to safety zones, or what was the term? I think yeah, well, no, the Artemis Accords use safety zones, actually. So the idea that you can create a safety zone around your operation. And I think what we need to start with is this soft law building approach of creating some form of understanding that we should not allow for individual countries to really monopolize the most important sites. With the technology, it's difficult for me as a lawyer, and I'm you may not often encounter a humble lawyer, but I'm trying to play one right now. I don't know much about the technology. I need to learn a lot about that in order to really understand. I think it's important that there will be some form of a safety zone about specific operations, because otherwise they can't operate. But do we really need safety zones of 20 miles or something like that? Or what is the feasible safety zone size that we can work with? And I use this just as an example of a very specific element to fill in the general concept of a safety zone, which I believe everyone can understand and can live with, because it makes a lot of sense. We have the concept of safety zones, for example, when it comes to oil platforms, but there we have a specific figure and everyone agrees to that. As long as we don't have something like that in outer space, that might be a recipe for conflict. I'll stop there, but.
So Professor Erlank, I realize that your work is largely as a property law professor and specifically in space. And so given some of the issues that Dr. Vonderdank had just raised regarding those very property issues, I mean, what's your opinion on the need for the safety zones, or are we heading towards a property regime on the moon?
Yeah, thanks. Just a point of clarity. So I'm from Northwest University in South Africa, not Northwestern. So if you're from Northwestern, you don't know me, don't worry. Oh, and I don't know Elon Musk. But I do come from the same city as Charlize Theron. Okay, that being said, a bit of levity is always good in space law. And being academic, we do have luxury of a bit of white ivory tower thinking. So the first thing, property and ownership, and then at the end of the day, Article 2 is all about property, isn't it? So it's about appropriation. And appropriation is what ownership is to a private person, appropriation is to a government. But at the end of the day, the issues are the same. So we tend to think about ownership, and when we talk about ownership, we tend to think about exclusion. So what can I do to prevent you from coming onto my property or using what I have? And there I've carefully inserted the word use. So in terms of the OST, it's quite clear. It prohibits national appropriation, and it quite clearly or very loudly omits private appropriation. And while I was looking into this, I've been dealing with this issue for about 14 years. First, I said, well, no, this needs to change. Outer space treaty is outdated. This can't be. States need to be able to have ownership. And then I realized I'm wrong. And I changed my mind. I said, well, let's allow for private, at least private appropriation. And then I realized I was wrong. And I'll probably realize I'm wrong again in the future. The problem is, when we go back to exclusion, this is about the safety zone. It's a physical impossibility. You cannot be in the same position as anyone else at the same time. The same goes for bases that are placed on the moon in terms of Artemis or any of the future things that will come. Ownership is the word that we use, but let's ignore it. Let's say that we want to achieve the same thing in terms of the Outer Space Treaty, which prohibits appropriation, prohibits ownership. you cannot make it your national territory. But if you create the base, as you stated yesterday, and you stay there for 50 years or 100 years, you are preventing anyone else from using that same place. If you situate yourself at a place which has good mining potential, and you make the safety zone 100 miles, 200, 1,000 miles, you are preventing anyone else from using that resources at the same time. So we must be very careful that we do not allow for ownership creep or appropriation creep to come in via the back door. The other thing that I just want to put to you, it's a bit contentious, but is the thing that I like to talk about as appropriation by proxy. So it's all good and well if we say, well, we allow for private appropriation, we limit the extent to which this is allowed. It's only a small piece that you can mine in a specific area, and when you're finished, you lose your rights to it. Nothing strange about that. But I do have serious worries when you consider that nations are obligated to maintain supervision, control, and authority over their citizens. So if a nation maintains supervision, control, authority, jurisdiction over their nation, their citizens, who are private citizens who obtain private ownership in outer space, are they not thereby obtaining by proxy territorial sovereignty? I will just leave that there for the moment.
Thank you. So I'll just throw that out to the rest of the panel. Actually, that's a pretty contentious or interesting idea. Does anybody have any response to this concept of appropriation by proxy?
So, so yeah, I'm an engineer by training, but a space operator by career. We used to say, you know, if there's two people and one gets halfway closer to the other and then halfway closer do they ever touch, a physicist will say, no, they never touch, but an engineer will say they get close enough. So maybe by proxy, they're getting close enough. I want to expand on some of the concepts we've also talked about. This concept of non-interference, this exclusion, I think is something we're going to have to really delve into a lot. And it's going to depend on what the activity is. I can imagine a scientific activity where a very stable lunar surface is required. And if you are mining, I'm going to assume that there's going to be some vibrations that cause, you know, that vibration to traverse the lunar surface. Could you say you have to stop that mining activity because you're interfering with my scientific system that got there before you did? Or is there some sort of sharing arrangement or scheduling that needs to be deconflicted? And let's also not forget that we're not just talking about the lunar surface, but we're talking about key strategic points, the Lagrange points, for example, that will be critical to not just get resources to and from the moon, but also communication links and domain awareness of the activities going on in the entire cislunar regime. So I think we need to look at our interference considerations in the larger context as well. And then finally, you know, you hit on this point that the resources that we're talking about, they're not infinite, right? Space is infinite, but the resources that we're seeking are finite. And anywhere humanity has gone to compete for scarce resources, such as ice in the craters of the South Pole of the moon, you know, we potentially have conflict. And so that's why I think I'm here to talk from a military perspective. What can we do to help preserve and protect, secure, in another word, those interests that we have from potential violations or mistrust?
Well, sir, before, go ahead, ma'am.
Sure. Hi. I just wanted to clarify that in the Artemis Accords, the safety zones are not envisioned, at least in principle, as a keep out zone. They are a notice and consultation mechanism so that states would provide information about their activities to other signatories and other actors who are in the area so that they can then consult about their activities to ensure that they are not in conflict with one another. And of course, the Artemis Accords also emphasize that the lunar activities or activities in outer space have to be done, in particular space resources, have to be done in conformity with the provisions of the Outer Space Treaty, which would include the prohibition on non-appropriation. And at least the United States would implement that through our regulatory framework and through licensing conditions or provisions that would ensure that we're able to comply with our obligations with respect to free access, for example, to all areas of the moon and other celestial bodies.
Professor Vanderduck, I believe you had a response.
Yeah, thank you. Maybe you by now are aware of my love of elephants in the room, and there's another elephant in the room, because obviously you're absolutely right. The Artemis Accords do only provide for, and that's why maybe the term safety zone is a little bit unfortunately chosen, but that's a semantic issue. It's supposed to be merely an information issue. But of course, the big elephant in the room is what happens if somebody doesn't want to consult with you. Suppose there's a US base on the moon and there's a certain safety zone of, let's say, 5 miles for the sake of argument. And there is a Chinese rover which is about to enter that zone. And you send out, the message, it looks like you're entering our zone. Can you please contact us? And we have to come to an agreement about how you can safely enjoy your right of free access. And the Chinese said, we are not going to consult with you. Our right of free access means that we can simply go through. What are you going to do then? That's, of course, are you going to take certain measures to defend the operation which you might think is threatened by their unwillingness to cooperate? Or are you standing down and say, okay, let's just hope nothing bad happens? That's, of course, the problem. And that's why I think it is, and I know the Artemis Accords are, for a good reason, starting at a low level of binding force, because we need to get ourselves acquainted with what it really means to operate on the moon. And hopefully this will pan out. But we need to address these issues at some point in time, I think.
Absolutely. I think one piece of good news that just broke overnight is that the Chinese submitted a submission to the Space Resources Working Group and the legal subcommittee of COPUOS just overnight, outlining their suggested principles for space resource activities. And the good news there is that they're indicating that they are interested in communicating and cooperating. One of the principles that they outline is the need to have coordination among countries consistent with Article 9 of the Outer Space Treaty. So there, I think, while yes, we have to have plans for all eventualities, we are seeing some positive indications that for the safety of everybody's activities and the sustainability of everybody's activities on the moon, all of the major players are interested in having those consultations and communications.
Colonel Galbreath, I believe you had a response.
So I'm just going to pile on to the elephant because certainly we have here on Earth internationally agreed to norms of territory and 3 miles and things like that. And yet, how often do we have incidents where one country says you're within my territory and another country says no, I'm not? And let me remind you, we have GPS, right? You know within feet where you are. So why do we have these conflicts, these tensions over where these ships were, where these aircraft were? Now take that to space, to the moon, where we don't have GPS, where we don't have a good means to navigate with a surety the distances that we're talking about. I applaud the efforts at COPUOS, and I hope that we can get to an international agreed to set of norms that benefit all. That is absolutely the goal. But anywhere we've had norms, countries like China in particular have gone out of their way to stretch those norms, to try to get additional capability. And that's why other means to verify is absolutely critical to understanding and enforcing those norms. Without an enforcement mechanism or some way to verify, they're just words on paper.
So we had a presentation yesterday on lawfare, and it strikes me that we are discussing a filing by the PRC in this very context. I mean, do we think it's a genuine filing that they want to follow these particular norms of behavior, or is this an example of them trying to set the stage in order to drive their own position using that as a mechanism? Open that up to the panel.
Guess I'll take that one. I think it's probably posturing to do exactly what you just said. I think there's another elephant in the room, right? They established the Strategic Support Force before we established the Space Force, right? An interesting fact is that their astronaut corps is housed within the Strategic Support Force, right? They not only have that, but the China Manned Space Program reports directly to the Ministry of National Defense and the Central Military Commission. So their manned space program is very clearly military, right? And when you have Chinese personnel placed on the moon and they start building facilities, I think it automatically begs the question of, have they violated the Outer Space Treaty? The Outer Space Treaty says that you can't build a military facility. What constitutes a military facility? It says you can't conduct a military maneuver. What constitutes a military maneuver? Those have not necessarily been defined within the space domain, particularly on other, foreign celestial objects. So I think that there's a lot of elephants in the room on what does it mean when these things actually happen? If that constitutes a violation of the Outer Space Treaty, then I mean, if we've passed that threshold, I think we are now entering into a whole new era where we're going to have to rethink a lot of things. So when it comes to Copious and some of their other statements and policy documents that they've put out, historically speaking, to your point, with a lot of the things that they've done in the South China Sea, which is very synonymous, I don't know if I would fully trust the more kindness maybe that some people might assume that they're trying to cooperate heavily. A lot of their actions might speak elsewhere. So
Yeah, so I agree with you on many of those points, and particularly the demonstrated practices of China, and the head of their lunar program has compared the moon to the first island chain. Okay, let's look at what they've done in that first island chain. Let's also look at the rest of his statement. He talks about, if we don't go there, other people will go there and keep us from going there. It's a very territorial mindset. Whereas when we went and continue to go, it is for all humanity. We are trying to share information. We are trying to create this collaborative environment, which is counter to what we see demonstrated by China. The fact that the entire Chinese space program is run by the PLA is something we can't ignore. But let's not forget that, the 12 astronauts that we put on the moon, I believe 9 of them were active duty military at the time, and 1 of them was a reservist. That doesn't mean that violated the Outer Space Treaty by any stretch of the imagination. They were there supporting NASA in a civil activity. So it's one of those nuances that I think we're going to have to explore further. But it just goes back to the Outer Space Treaty established in 1967. A lot has changed in that time. And I think the legal standards, the norms, the way we interpret that all have to continue to evolve to meet the modern reality and the reality that we're going to be creating for ourselves in the future.
Mr. Sunby, you're one of the industry representatives that we have here. Would those norms be enough, right? What does your company need in order to maintain an economically viable position, in order to spend tens of millions of dollars to go to the moon and potentially extract resources? I mean, are you going to need to see some sort of binding formation, or would it be enough to just have the soft law approach?
yeah, well, first I'll just describe a little bit about what we do so people understand. So TerraSpace is a company that I helped co-found that develops machine learning applications for mineral analysis. So what that does is it essentially replaces a lot of the human oversight in that process. for existing mining operations here on Earth, right? So this is a very common thing that that mines deal with, is when they either want to start a mine or they want to expand, they have to take a lot of core samples to understand exactly what's there, understand the economic feasibility of actually even mining that area. And that process is generally fairly long, a lot of human oversight. So we came in and took a lot of the sensors that they already use and actually applied some machine learning algorithms to that process and determined that it was really, really successful. And so now we can do that both here on Earth, but we want to extend that, of course, in the future into space, which will allow us to, instead of doing extremely expensive sample return missions, we can probably get a lot of data, if not most of the data that you would from the sample return, actually on site and relaying that back here to Earth. To the legal aspect of that, currently, I think that the soft law approach would work currently. However, there, of course, are concerns that both TerraSpace probably holds and most other companies in this area of what happens when something is discovered, right? We know a lot about the moon, but we also don't know a lot about the moon. The deepest core sample was 2.92 meters. I believe that was on Apollo 17. The expectation is that the regolith ends around 3 to 5 meters. So technically we haven't even gone beneath the regolith, right? We have a lot of expectations of what's underneath the regolith and how it's formed. We've done an impactor mission where we actually impacted the moon and tested the ejecta, which gave us some interesting information. So, you know, going deeper, right, you might discover something that you didn't know was there. I mean, our own country, and I was talking to you earlier about this, right? Our own country, I think, is about 80% of it hasn't even been mapped geologically for critical minerals. The DoD put that report out earlier on in the Biden administration and suggested that we need to take action to discover what else is out there. And of course, you've probably been paying attention to the news, and we found helium, the largest deposit of helium that we've ever found just last week. The Resolution copper mine in Arizona just discovered a bunch of lithium. So we're finding new things, right? And that's just here on Earth where we live, and we're here every single day doing these operations. So I hope that leaves an impact on everyone that, yeah, we really don't know that much about the moon because we're not even there, right? We visited a few times, but we don't have a sustained presence. And so when we do find out what exactly other minerals are there at deeper levels, right, that's going to create probably a lot of buzz around, well, yeah, I mean, the US allows private companies to extract, right? I mean, that's very clear within policy directives and executive orders, and even our own Congress has passed, laws that enable that. But only a handful of countries have done so, right? I think Japan, Luxembourg, the US, and the UAE are the only countries that have done that domestically, right? That's not an agreed upon international norm. It's not necessarily against the Outer Space Treaty, but it definitely calls into question how are other states going to react to that. And so there are protections from freedom of action, right? So when we get into the security side of things, how might states respond when something's discovered? Private companies probably want a sense of security. Just like you see mines here on Earth are secured and controlled, private companies are probably going to want that too. So hopefully that answered the question, but sorry for the long.
It's perfect. So it sounds like there's a lot of both domestic and international interests that face the industry that's going to be heading out and actually conducting this resource extraction. Ms. Pierce, what are the efforts that the U.S. has undertaken to maybe push for these kinds of changes or these kinds of policies on the international level in support of these industries?
Sure. So there are two major efforts. There's the working group on legal aspects of space resource activities in the legal subcommittee of UN COPUOS, to which I'm the head of delegation for the United States. And the second is the Artemis Accords, which I'll talk about in a couple minutes. The working group was established in 2021, 2022, And last year, 2023, was the first year of its 5-year work plan. The mandate of the group is to collect relevant information concerning space resource activities, including with respect to scientific and technological developments, to study the legal framework that's applicable to the activities, to assess the benefits of further developing that framework, and to develop a set of initial recommended principles for these activities. The U.S. position on setting up this working group was we thought it was too soon. My predecessor in this position, Gabriel Swinney, said yesterday that we don't know what the needs or the risks are yet. We don't know what locations we're going to be most likely to be most viable, and we don't know which technology will be successful. So we weren't, I would say, very excited about having this group undertake its work. We thought it was premature. But if we're going to have the conversation, the United States is very much wants the work to be informed by the science and technology and by non-governmental stakeholders. So in order to achieve those two ends, the working group is going to have 2 events this year. There's going to be a UN expert meeting during Space Resources Week in Luxembourg later this month. It's going to be a day-long meeting where we are going to hear from outside non-governmental experts in a series of panels to help us understand the science and technology, as well as to understand the economics. The United States, we put out a Federal Register notice for those who read the Federal Register frequently, soliciting non-governmental interest in participating as experts in that meeting. And I'm very excited that we have 3 U.S. experts who were selected to participate in that event. So we have an expert from Blue Origin, one from ICON, and one from the Colorado School of Mining. So we're getting those outside technical, economic views into the conversation at the UN, which is vital. In addition, I'm very excited that Jerry Sanders, who gave the lightning talk just before this panel, is going to be joining the U.S. delegation at the legal subcommittee, so that when we're having these working group conversations, you know, among lawyers and diplomats at the UN, I can have somebody next to me with the scientific and technological background who can say, hey, what that country just said doesn't actually make any scientific or physical sense. And we can have a better and more informed conversation. And then the second part of the event is going to be a conference during the legal subcommittee in Vienna, which I think is going to be less useful because those are going to be government experts. It's going to be government people talking to government people, which I think is, from my point of view, going to be less useful. So the event in Luxembourg is really going to be exciting. We're also considering other avenues for getting those voices into the conversation, from submitting stakeholder views into conference room papers at the UN that can become a part of the written record of the working group, from potentially having a listening session with industry as we move towards the drafting and negotiation of initial principles, ensuring that our non-governmental industry stakeholders are able to provide feedback into that negotiation process. As well as we'll probably be having another Federal Registry notice soliciting interest in participating as a private sector advisor on the legal subcommittee delegation in April. So the second principal effort is are the Artemis Accords, which we've talked a lot about over the last day and a half. And Section 10 on space resources activities really makes incremental progress in this area. We hear lots of sweeping statements about it. It acknowledges private ownership rights. That's not actually what the Artemis Accords say. So it does four principal things with respect to space resources. The signatories acknowledge that space resource activities can contribute to safe and sustainable space operations. Second, the signatories state that space resource activities should be done in conformity with the Outer Space Treaty. That's pretty obvious. And they say they should be done in support of safe and sustainable space activities, which is also something that we saw in the PRC submission overnight. Third, they affirm extraction does not inherently constitute national appropriation under Article 2, and that contracts should be done consistent with the Outer Space Treaty. So here, I think, is where we make some incremental progress. It's not inherently contrary to Article 2, but it's a small step. So while I noted, yes, while there are only 4 states that have domestic laws, there are 30, almost 40 states that have signed on to the Artemis Accord. So while it's not a part of their domestic law, they have made this political commitment that it's not inherently national appropriation under Article 2. And then lastly, they're going to share information about their activities with the UN, and they're going to contribute to the effort, the multilateral efforts, including at COPUOS, to develop best practices, to develop these rules. So we are working with other experts among the signatories to ensure that we're not working against one another in the working group. In particular, there are some Artemis Accords signatories who are also Moon Agreement parties, and we want to make sure that we're not pushing towards an international regulatory regime at this time. It's not just premature, it's not the US position. So how do we bring all of the Artemis Accord signatories along at COPUOS? And I think that's where we're going to be in non-binding land, non-binding initial set of recommended principles that are going to be fairly high level at this point as we wait to see how the science works out and the technology demonstrations. We need technology demonstrations before the lawyers can start working with the experts to draft the rules.
Professor van der Duck, do you have a response?
Yeah, thank you very much for that very excellent explanation of where exactly because I'm focusing now again on the point of appropriation and going back also to your point, where the one sort of avoids the other. Because of course, when we talk about appropriation, we should always be clear that there's a fundamental distinction between appropriation of an area, which is clearly prohibited, and the question of can you appropriate the resources therein. Going to your point where you were worried about sort of a appropriation creep, I'm wondering to what extent I would turn it upside down. Technically, legally speaking, that's not possible because as long as Article 2 is there, you cannot use subterfugeous means to still create any form of sovereignty. That doesn't mean that the main problem of long-term occupation might raise the issue nevertheless. My question is to you in particular, to what extent could we avoid this by making, I mean, what are we appropriating? Are you talking about the appropriation of the resources, or are you talking about a concession to use or mine for a certain period of time a particular place, which I believe, I'm not a mining expert or not a mining law expert either, but which I believe is often something that can happen on Earth. If we again make the comparison with the ITU, just like on the moon, there is no possibility to appropriate any part of the geostationary orbit, yet we have all come to a general agreement in this world that having a satellite operating for 25 years in a geostationary spot does not violate Article 2 of the Outer Space Treaty, and it has been sufficient, at least in the telecommunication context, for a multi-billion-dollar commercial sector to evolve. Is that something that might solve the issue of the risk of an appropriation creep?
Yeah, thank you. A couple of interesting questions in that. I think in the first place, yes, I agree. I'm not so much concerned about the appropriation creep. It's just something to be careful of. But I think the Article 2 is quite clear about that. The ITU is, of course, a very good example, but it is so unique. We had the word unicorn yesterday. I think the ITU is a unicorn in terms of the UN, since everyone agrees to and subscribes to it, because they realize if we don't form part of this, we lose out 100%. So there's no option but to come to the table. I think the bigger, let me rather talk about something I think I can give an answer about, is about the extraction or the appropriation, if you want, of resources. So let's look at what the actual convention says. And the convention doesn't say anything about that in Article 2, but it does say something about it in Article 1. And it says that outer space, including the moon and other celestial bodies, shall be free for exploration and use. And it comes down to use. So what do we mean when we say use? Do we include use up? And that is the important thing. If we use something, we're using these chairs, but after we leave, someone else can use it. But if you use a can of Coke, it's gone. Nobody else can use it. And the same goes for most of these mining activities. I was reading about the stats regarding helium-3, for example. There's a lot of it, but there's not a lot of it. So if we use it up, it's gone. So do we allow for this to happen? Do we say that this is acceptable? Because by using it up, we are taking away something that cannot be used by anyone else or by the rest of the international community anymore after that. So this is where the race comes to finding the Goldilocks zones. Whoever's in the ball pit first gets to play with the nice balls, and everyone else just has to pick up what's left. So I think what we will see happen is that there will be some sort of state practice. We've used that word, but also private practice, if you want, commercial practice. The first people to go and commercially extract. And I think that is the key. I think we're all quite happy to say that if scientific extraction happens, that's fine. We don't mind. We can drill and leave craters and so on, and that is for the good of all humankind. But as soon as you take something out and you mess it up and you leave mining tailings behind and you shoot up dust into the, well, not the atmosphere, but into orbit around an asteroid, you're creating a lot of issues that will affect everyone else. But it will happen. As we explore, we're going to start doing this. It's the only way to start building housing on the moon or Mars. We will have to interact with the environment. So I think the first time that we see the first commercial company go up, gets it done, and it will probably happen in terms of a country that has national laws that says, well, we will support this. We will see the new kind of gold rush happen, and everyone's going to race for the nice spots. And then it might come down to asking, well, if somebody wants to kick me out of the ball pit, who's going to protect me? I want a guaranteed return on my investment. These guys are bullying me. They want to take away my sweet spot. Who's going to help me? And I think then we can ask interesting questions about similarities to the marine commercial corridors. Sorry, I haven't answered all the questions, but I'll leave it to.
Colonel Galbreath, I believe that this dovetails well into some of your work and thoughts on this, because I mean, wherever there is a race to particular locations, as well as vast sum of money involved, the national security apparatus is not far behind. So would you mind talking a little bit on what is the expectation on the U.S. military to secure these areas, and how can they be helpful in actually maintaining and protecting these commercial assets?
Yeah, so thanks for the question. I think there is an expectation that the military will provide some level of protection. The same way that the Navy provides free access to the sea lines of communication, although we're seeing that tested, even today. But there is that expectation that the military will be there to protect your access to what should be free and open lines of transit. So I think, what does that look like for the Space Force in particular when we head out to cislunar? It starts with domain awareness. We have to be able to provide clear and unequivocal proof if there is a violation of someone's claim or to someone's scientific activities, or if someone is behaving in an irresponsible or dangerous manner. We want to be able to highlight that and say, cut it out. And then there will probably be diplomatic or even economic means here on Earth that will be the mechanisms for enforcement. I'm sure when some people think, okay, retired Space Force colonel is going to talk about what the military role is. Okay, we're going to talk about lasers and weapons in space, and gosh darn it, we're going to protect that claim. No, I'm a much more peaceful, loving type of space warrior. And that is, let's start with awareness. Let's try to enforce that via legal and economic means. If that turns out to be impossible, right, and if there is a continued belligerence by a party, that's when we need to start thinking about other means of enforcement. And that I hope is continuously in the future, as opposed to what we're seeing now, which is some activities that we're saying are future are also happening today with private moon landings and international moon landings going on. So sorry, a long way to answer, but I think it starts with domain awareness. I think there are other key elements that the Space Force can provide in terms of navigation to say, yep, you were here, and we can identify that. I think, no kidding, communications via laser link, for example, might be essential. So there's an element of what the Space Force and what the military can provide from an infrastructure perspective that commercial and civil activities can then build on and not have to duplicate themselves. And I think that not only accelerates our peaceful purposes, back to your point about you got to get there first, but it also enables the Space Force to secure those interests as they develop over time. I want to just kind of tie two themes together. Yeah, if you drink a Coke, it's gone, but most machines today, and I'm not a mining expert, but I would imagine that there isn't a 100% efficiency when it comes to harvesting the materials from the regolith or the ice from the crater. And so is there a means to glean what's left behind by the initial party? And are there arrangements that need to be established along those lines, back to what we were talking about from a State Department perspective? Go ahead.
Yeah, and to that point, I mean, talking about the mining side of that, right? That's very applicable here because here on Earth, when we mine, there are some mines here in Colorado where they will throw away a good 60% of what they're mining because that's not what they're looking for, and sometimes they don't even know what's in it. And what we're finding is, oh, hey, there was lithium in there, or hey, there was this rare earth element that you just completely ignored because your company wasn't focused on that mineral, right? They're not in that market, right? So that same thing's probably going to happen in space, which then alludes to who's coming in behind, right? Some of the companies here on Earth are adapting and they're realizing, well, we can now expand into those other markets, and so they maintain their presence in those areas. Others are leaving, and then new companies are coming in. So, I think that would lend a lot of credence to what we would see in on the moon and other celestial bodies in the future, for sure.
So there was a great question posited this morning by Dr. Malgrim regarding what happens when we have completely on orbit developed objects. Things that have no defined launching state underneath our current confines. Would any of our lawyers on the panel like to opine on how that might fit into the current outer space treaty regime?
I'm looking for a volunteer for a doctoral dissertation to engage in those questions. It's a fascinating question. It has already been, to some extent, been very much on the surface being addressed when it comes to the future of using resources on the moon to build stuff on the moon. But this is basically the same thing. And the short answer is clearly the Outer Space Treaty never was aware of the possibility of something like that happened. And then there are basically, as a lawyer, I would say 2 ways to change, or maybe 3 ways to change that. One is to formally amend the Outer Space Treaty. Like any international agreement, there's a possibility to create amendments. There has been a, I think, very legitimate concern that if you open the discussion on certain clauses of the Outer Space Treaty, that you open a box of Pandora and that you end up with something far worse than is right there now. That would basically also be my opinion. The second opportunity is that you allow for some international agreement of potentially, let's say, a customary international law agreement, that you sort of ignore that part of the Outer Space Treaty, that everybody agrees, well, without changing it, we can ignore it. I'm in this respect a little bit of history reminded of what happened back in the late 1940s and early 1950s, when in the law of the sea there was a prohibition to exercise territorial sovereignty beyond the territorial waters, including sovereignty or sovereign rights to claim resources. Then President Truman came out with a statement saying that we think that because of the natural prolongation of the US territory underneath the waters, the continental shelf, as far as out as that reaches, much further than the 3 or 12 miles or whatever it was at the time, should be subject to US sovereignty as it comes to mining thereof, which was technically speaking against the state of international law as per the treaties and customary law at the time. But rather than the rest of the world saying, hey, you are now violating international law, most countries basically said, oh, that makes a lot of sense, and started claiming their own continental shelves. And then, of course, much later that got sort of replaced in a new treaty. So that's one option which may hopefully, or which may possibly solve this issue. And the third one is just by creating bottom-up national legislation and practice, and at some point saying, well, we just ignore it, right? I'm not sure that, don't quote me in class if anyone is doing that, because that's not a legal tool that you're supposed to use. But the real world sometimes, you know, makes us forced to take these steps for the, let's say, for the betterment of humankind. That's all I can say.
Ms. Pierce, it looks like you all.
Yeah, I'm just interested to know which parts of the Outer Space Treaty, in the context of manufacturing an object in space, would need to be ignored. I think that if you are manufacturing something in outer space and then that thing goes and does something else, those are all activities. And the Outer Space Treaty speaks to activities. Potentially, we're looking at the provision that's referring to the obligation of states to maintain jurisdiction and control over their space objects that are on their registry. And in that case, maybe you would need to look to amending the registration convention, or at least starting off by developing new best practices or voluntary measures for enhancing registration. So if a state wanted to provide registration information for objects that are manufactured in outer space, they could do that on a voluntary basis as state practice develops in this area. But I don't know that the Outer Space Treaty, and I certainly wouldn't advocate that the Outer Space Treaty would need to be ignored with respect to objects that are manufactured in space.
Yeah, you're right. I stand corrected. I let myself be carried away. The second part, which I should have added, is that even if it's already possible to create by customary international law sort of an ignorance of a certain treaty obligation, it is even easier to create by international, customary international, something that the Outer Space Treaty does not deal with. Because you're absolutely right, there's no obstruction to constructing anything in outer space. The problem is, of course, that because so much of the Outer Space Treaty's rules are premised on something being a space object, and a space object so far has always been defined as something being launched from Earth into outer space, as opposed to being manufactured in outer space, that rule does not, as such, apply to things that are manufactured in outer space. You're right, Article 6, which requires national activities in outer space and does not mention space objects, would still apply to that. I don't think that's sufficient in order to have a full-fledged regime, because it ignores the liability convention, which again is premised on something being a space object. You spoke about the registration convention. So that's where I would imagine that a lot of additional state practice could de facto add to this and say, well, we interpret the provisions of the Outer Space Treaty, which technically speaking only apply to space objects, which in turn, technically speaking, are those launched from outer space, also to any object made by humans in outer space. So you're absolutely right. It's not so much that you are violating the Outer Space Treaty, it is that you have to amend it de facto to the extent of taking care of these new developments as well, in the same way that the Outer Space Treaty has been able to take care of space objects so far.
Dr. Erlank, I believe, had a response, and then Colonel Galbreath.
Thanks. I'll just quickly agree with you. I think the low-hanging fruit is the definition of a space object. So our definition that we have is no definition at all. And I think the only thing that we can kind of agree on, it's premised on the fact that it's launched or reported or destined to be launched. So if an asteroid comes in, becomes a meteorite, and lands on the Earth, and we take it back out into outer space, and we leave it, and it crashes into a satellite, that will be a space object. So I think the first thing is just to, well, we don't have a definition of space object, but the kind of understanding that we have, let's just include the fact that anything manufactured by man, human, in outer space or on the Earth. So in other words, anything that we do to change the environment will have liability aspects to it. But of course, never forget the fact that people don't want liability, and especially private actors will not want liability. And we can see that in terms of the current adherence to registration. We don't see registration, and no country registers any of, well, most of their assets. So in outer space, we will not probably see that. I see it's one of the goals of the Artemis Accords as well, more registration. But yeah, private companies making new things will not like that very much. But of course, when you create a new superstructure in outer space, a new space station, people will know about it. And we might ask them to register it. Yeah, interesting.
So not a lawyer. And I didn't even sleep at a Holiday Express last night, so I'm really going on a limb here. But as a fellow who writes papers, I use words a lot, and words have meanings. And so far, the meaning, the definition of space object has been one that generates from the Earth and is moved to space. That's because that's all we've done. As we do something new, that definition, like many definitions, will continue to evolve and change over time. But I want to look at it from a different perspective too. Again, the engineering hat on. That thing that is manufactured in space isn't just put there to be there and that's it. It's going to do something for someone and must probably communicate or interact with something else. So is there a way by proxy to associate an ownership or a responsibility of whoever manufactured that?
Yeah, I don't want to open Pandora's box here, but we're getting closer every single time. Yeah, that's exactly what it is. I was chatting with a couple of you before we came out here, and something that's just interesting to note is kind of on this topic is in the Starlink users policy agreement. If any of you have Starlink, you might not have read it, but there is a section that actually states that you are agreeing to the fact that there is not international law that governs the use of this device on a foreign celestial body. Pretty sure that's what it says. I'm not exactly, I would need to go back and read it. I don't know if you've seen it, but it actually states that it pretty much rejects international law in a way. So does that, does that really open Pandora's box, especially the hint in the user's agreement, particularly when this is used on Mars or the moon or somewhere else, not on Earth? And so what does that mean, right? I mean, that's not necessarily a manufactured device that's been created from resources beyond Earth. It could be in the future, but what happens when companies take those stances and they're on foreign celestial bodies like that? That's kind of Pandora's box, maybe, but
Just a clarification, does this clause state that there is no international law applicable to use on celestial bodies, or does it state that whatever international law there might be, we ignore it?
I believe that it states that there is no international law.
Which probably then focuses on, no, oh, I'm sorry, gosh. No, but maybe that focuses then on the use of frequencies, because the ITU has so far not dealt with frequencies on the moon, as far as I'm concerned, between, and going back to the history of the ITU, there was a specific requirement back in the days when shortly after Sputnik went up for the ITU and the ITU member states. We always talk about ITU, but essentially it's still composed of sovereign member states to agree that ITU should have the competence to also address space frequencies. So maybe this is what they're hinting at, that before the ITU can start applying its process for coordination of the use of frequencies to cislunar frequency operations, none of the transmitters being involved being on Earth, which is still the case so far, that requires a new, maybe it's that's what they're focusing on.
So it looks like we have about 14 minutes left. And so what I'd like to do is I'd like to give our panelists an opportunity to opine on any last topics that they maybe wanted to hit prior to the conclusion of the panel. And I'll just go straight down the line. So sir, starting with you, if you have anything.
Yeah, perhaps just a little bit of Latin. So a lot of our things that we discuss in terms of appropriation and ownership, whether we can extract, whether we can use, comes down to a very concrete decision taken when writing the OST about the difference between res nullius and res communis omnium. So in terms of Roman law, when something is a res nullius, it belongs to no one. It might have belonged to someone previously, but at that moment it belongs to no one, and therefore you could acquire it. So you could become the new owner. As such, it was placed inside of commerce. But then you had a separate category, which is called the res communis omnium, which literally means things belonging to everyone. And that includes the air that we breathe, the sea and the sea, the water and the sea, things like seashores generally. And it was accepted that this cannot belong to anyone specifically, and therefore belongs to everyone. And it was outside of commerce. Except if you could exert your control over it. So if you take a bucket to the sea, you take a bucket of seawater, that bucket of seawater is now yours. If you do scuba diving, you compress the air, you can exert your control over it, put it on your back for scuba, it is yours. So I think that in outer space, we will see something similar arguments being raised in terms of extraction of minerals, exerting control over it. We can go into lock-in labor theory and sweat of the brow, but I believe those are some interesting discussions that we'll see going forward. The semantics are important.
So first of all, thanks for the great discussion. I've learned a lot from everybody here. So thank you for the opportunity. I want to remind people that this is a race. There are limited resources and limited key terrain features on the moon and in the cislunar environment. And as we go out further into space, that we will be competing for. And so unless we somehow establish a legal regime that defines how we're going to share all of that in the future, whoever gets there first is going to establish the precedent, is going to establish the customary law for how that's going to be utilized. And so it's incredibly important that those nations that have signed up to the Artemis Accords and have the views of sharing these spaces openly and freely for the benefit of all humanity, it's important that they get there first. And we can't tolerate a territorial mindset from any nation as we move forward. So what's the role of the military? I'm just going to reiterate the domain awareness, the communications, the navigations, those same things that we've done here on Earth to establish things like GPS or satellite communications or the internet. Those are the types of things that we're going to need to be doing in the cislunar environment. And I think that will be a benefit to all humanity as we do so.
Dr. Vanderdup.
I pass. That should give at least 5 more minutes for questions.
Well, and Colonel Galbreath, to your point, right, earlier that you made about the Navy, right, that synonymous metaphor, I agree with that, right? Particularly as we have developed the Artemis Accords and you have China and Russia discussing the International Lunar Research Station Organization, which should, based on the information they've given publicly, it's supposed to be a treaty-based organization. Obviously, there's blocks being formed, right? I mean, I think that's very clear. And to Professor Vanderdunk's, points, I don't see the Outer Space Treaty opening that back up for amendment is Pandora's box. That's Pandora's box. And so I think going forward, our country has taken the right step with leading in the Artemis Accords, but we also need to be very clear that just like we protect the high seas, we need to make sure that we do have a security apparatus that can maintain those norms that are established within the Artemis Accords. So, yeah.
Ms. Pierce, any final comments before questions?
I think that obviously I just wanted to emphasize that we need to be driven by the science and technology and the actual activities that are possible and feasible. And as a lawyer, I need to allow that development to happen so that it can inform the rulemaking. What I'm working against in my day-to-day job is to ensure that we're not getting out ahead of what's possible and what's happening. In the meantime, however, the United States does have the obligation to authorize and provide continuing supervision under the Outer Space Treaty of our non-governmental activities. And here, that's where the administration's proposal for authorization and supervision, updating that regulatory framework is really important, because we are going to be, our industry is going to be at the forefront of these activities. And the more that we can demonstrate that we are doing our job domestically to oversee these activities, and doing it in a safe, sustainable, and transparent manner, the better case we're going to have to make at the international plane that our rules and our practices that we envision and that we're implementing are for the good of everybody.
I'd like to go ahead now and open it up to questions. I've been told that there are a few.
I'm Kane Rajiki, LNO to Space Command, US Space Command. So thank you for great discussion. So I understand the space capability is so dual use, and so it is difficult to the attributes whether some maneuver or some rendezvous and proximity would be non-cooperative or possibility threat or not. So from that point of view, my question is how to define what is irresponsible maneuver or irresponsible rendezvous and proximity. So I'd be happy to hear any thought about that.
I'll just jump in on that first. So I think Emily's correct in that we have to understand what the technology is allowing. And so, for example, if we were doing rendezvous and proximity operations for the first time, against an entity that wasn't expecting that or wasn't prepared for that, it might have to be further away, right? But as the technology matures, that distance can become less and less and less. And so I think as we advance our technologies and as we actually demonstrate the extent to which one activity could potentially impact another, that will define what we need. So if we start with, let's try to be as far apart until we have a firm grasp of what it is that we could be unintentionally interfering with, that would be ideal. I spoke with one company whose objective is to land on a SpaceX Starship, place sensors at different regions around that landing point, and then when it takes off, take measurements for exactly how much vibration is transmitted and how far. Until we get that type of knowledge, any projection we make about what a safe zone is just a guess.
Yeah, and I think to that point, you know, the plume that's kicked up, right, for any lander, both upon landing and takeoff, right, that could push resources that they might be trying to get away from that region. So I know that there's been a lot of discussion as to those zones being made in preparation for potentially how far that plume could be as well, right? And those are still unknowns. So to your point, you know, I think that that's going to evolve over time.
A key part of responsibility is demonstrating that you're sharing information and communicating with others about what it is that you're doing. And one of the steps that the Artemis Accord signatories decided to take last year at their heads of agency meeting on the sidelines of IAC in Baku is that they are going to be submitting to the United Nations certain data parameters about their lunar activities consistent with Article 11 of the Outer Space Treaty. That information sharing can help other countries identify activities that could potentially interfere with their own and then trigger the consultation requirements under Article 9. So I think communication and transparency about what you're doing is important. If you can show that you communicated with the other country that is responsible for the other object in advance of the RPO, then that demonstrates responsibility.
One other question on the floor here.
Hi, Janine Frazier. I'm with the Defense Threat Reduction Agency. The United States and the Soviet Union explored for a time the potential civil benefits of peaceful nuclear explosions in excavation and mining, things like that. And you could foresee maybe a time in the future where an entity viewed that as an advantageous approach to extraction on the moon or an asteroid or another celestial body. Do you think the implications for the Outer Space Treaty might be if someone tried to get around Article 4 provisions by declaring their nuclear explosive device not a weapon, but a mining tool?
Well, the Outer Space Treaty is not the only thing counting. We should be aware that the Nuclear Partial Test Ban Treaty prohibits any exclusion, any nuclear explosion in outer space, even for completely peaceful purposes. So for the time being, at least as far as the law is concerned, I think we're covered.
I'm glad to hear that, because when I was writing a paper on cislunar and how the military needed to be involved in it and what are the challenges we have to overcome, my wife kept telling me, don't F up the moon. And when I hear thoughts of, well, we're going to explode some nuclear bombs to actually do some excavation or something, that is the path to F up the moon. And so I'm glad to hear that that is prohibited.
Just to add a little bit more spice to that, in the context of planetary defense, which there will be a panel later on, there has been some discussions on the potential need or desirability to use nuclear weapons against an asteroid as a last way of preventing it from hitting Earth. And even though everyone clearly would applaud any, any effort to avoid the Earth from being destroyed, there still is this legal obstacle, which technically speaking prevents that from happening. So that's as far as it goes currently.
believe we have enough time for like a very brief comment, if that.
The very brief comment is that the Security Council could always, under Chapter 7 of the UN Charter, take action that could potentially allow such an explosion to happen.
And I think that that actually concludes our time. We have 2 seconds left. So they're pointing at me saying I have enough time to go ahead and have one more question. So.
Thanks. I'm Nicholas Fernandez from the United Kingdom Government Legal Department. So I've got my Outer Space Treaty open because if I'm going to disagree with Professor von der Dunk, then I'd better be sure of my ground. So when you talk about amending the Space Treaty to construct installations on outer space, I don't think we really need to do that because, as you mentioned, Article 6 does allow that. It basically gives international responsibility for national activities in outer space to governments. So basically, all we need to do is to be able to license the construction under Article 6. I don't think you need new legislation or new treaties. I think that is possible under Article 6. Liability wouldn't apply, but then under Article 7, but then maybe industry would be very happy with that. But the way we'd control it is through the licensing of construction, which is, or manufacturing, because that's a national activity in outer space. I think more difficult is the Article 1, where you say exploration and use of outer space and other celestial bodies shall be carried out for the benefit and in the interests of all countries, irrespective of their degree of economic or scientific development, and shall be the province of all mankind. I think that's going to be contentious because you get all these riches from planets. How are you going to benefit all mankind?
Thank you for that. And I apologize if I wasn't clear enough in my second iteration following Emily's intervention, because of course the Outer Space Treaty does not as such prohibit this, apart from the Article 1 issue, which is an interesting one, but that doesn't mean that there is a huge human interest in making sure that the Outer Space Treaty continues to cover also those activities, and not just under the Article 6 provisions, but also when it comes to liability issues. I'm sure there will be many private parties who would be happy to not be subject to any liabilities, but I don't think that's a good thing for the development of space in the long run. So that's why we need some form of de facto addition to make sure that also those newly manufactured things in outer space are not used to escape what otherwise would, you know, be a fairly sensible system. Yesterday I labeled that the beauty of space law, that there is such a regime for liability that makes states also liable for that. Now, this goes a little bit too much into detail. In terms of the time, I will not go any further, but Article 6 in itself potentially even allows for the possibility to claim